So good afternoon, everyone. Welcome to MVLS's Legislative Roundup Changes in Maryland Law this year. I'll be your moderator, Asia Mallory. I'm the Consumer Staff Attorney at MVLS. Today, our presenters will be Timothy Chance, our Tangled Title Attorney, Amy Hennett, the Director of Advocacy and Financial Stabilization, and Chris Sweeney, our Workforce Development Project Coordinator. Today, our topics will be estate planning and administration, housing and tax sale, criminal record expungements, landlord tenant, medical debt and bills, and the earned income tax credit. So our first presenter is Timothy Chance.
All right, thank you, Asia. So again, my name is Tim Chance. I'm the Tangled Title Attorney here at Maryland Volunteer Lawyers Service. And the first change in law that we're going to be talking about today that may impact our clients and volunteers is House Bill 1266. So with this addition to the statute, a person having custody of a will, so the non-testator, has a duty to maintain custody of the will. And without authorization by the testator, the custodian of the will may not destroy or dispose of the will, disclose the contents of the will to any other person, or deliver the will to anyone other than the testator. The custodian, testator, or testator's agent may deposit the will for safekeeping to the register of the county in which the testator resides or resided when the will was executed for a nominal fee of $5. Can we go to the next slide, please? All right, thank you. So after the testator's death, the custodian, if they are still in possession of the will, they must deliver it to the appropriate county's register for administration. Willful failure to deliver the will may result in liability to any person aggrieved for damages sustained by that failure. There are some circumstances in which attorneys who have custody of the will may dispose of it. So if the attorney is licensed to practice within the state at issue, at least 25 years have passed since the will was executed, and the attorney cannot ascertain the address of the testator after a reasonable inquiry, and the will is not subject to any contracts concerning specific devises or revocations, then it may be disposed of. However, they still must file the will with the register of the county in which the will was executed and submit an affidavit certifying that those conditions I just mentioned were met. The attorney may also destroy the will without notice in the instance that the will has not been offered for probate within 10 years of the testator's death. So attorneys who follow those procedures and those requirements and dispose of a will not be liable for any damages as a result of the disposal. Next slide, please. All right, thank you. So now I'm going to go over House Bill 1261, which allows for the electronic execution and remote witnessing of wills and powers of attorney. So to be effective, an electronically executed or remotely witnessed will or power of attorney must satisfy the following requirements. So at the time of signing, the testator and witnesses must be in either the physical presence or electronic presence of one another and a supervising attorney. And that supervising attorney may also be a witness. So electronic presence means two or more individuals communicating in real time using electronic audiovisual means to the same extent as if they were in the same physical presence of each other. And at the time of signing, the testator must be a resident of or be physically located in the state that will hold jurisdiction over the will or power of attorney. Any witness in the electronic presence of the testator when signing and attesting to the instrument must be physically located in the United States at the time of the signing, and they must also be a resident of the United States. And the testator and witnesses must sign the same instrument, or counterpart thereof. Next slide, please. So the supervising attorney must also create a certified will or power of attorney, which includes a paper copy of all the pages of the instrument and an original paper certification drafted by that supervising attorney. And in that certification, it must state the date on which the supervising attorney observed the signing and ensures that that attorney took reasonable steps to verify that all of these signatures were original signatures. It took steps to verify the identities of each witness and the testator, and that all the parties were physically located in the United States at the time of the signing and attestation. So a certified will created by a supervising attorney must also include the acknowledgement of the testator and the affidavits of the attesting witnesses before a notary public under seal. Can we go to the next slide, please? All right, thank you. So now I'm just going to go over some laws that will impact tax sale. So House Bill 852 establishes the Homeowner Protection Program in the Department of Assessments and Taxation for the purpose of diverting vulnerable homeowners from the private tax lien sale process into an alternative program with the intent of minimizing tax collection costs to owners, assisting these owners to pay their taxes, and allowing these homeowners to remain in their homes. This bill will create the right for homeowners to enter into payment plans to avoid tax sale. It will also create a fund for a state office that will assist homeowners with accessing payment plans and any available tax credits to prevent losing their homes to tax sale. And the effective date for this bill is July 1st, 2022, so next July. Next, there's Senate Bill 325, which alters the amount which a person is required to pay the tax collector to redeem property sold at tax sale by limiting taxes, interest, and penalties accruing after the sale to include only the delinquent taxes, interest, and penalties. This bill requires that after a tax sale, the property owner will only be required to pay delinquent bills in order to redeem the property. And they cannot be required to pay bills that are not yet delinquent in order to redeem. This bill went into effect on June 1st, this past summer. And then lastly, there is House Bill 610, which altered the definition of legal interest as it pertains to the homeowner's property tax credit program to include legal interest in the dwelling as a surviving family member who stands to inherit the dwelling of a deceased homeowner under the terms of either the deceased homeowner's will, trust, or non-probate instrument, or under the laws of intestate succession. So as a result of this, certain surviving family members who stand to inherit the home have a sufficient legal interest to apply for the homeowner's tax credit. And a surviving family member is defined as an individual related to the deceased homeowner by blood, adoption, or marriage. This change in the definition of legal interest is effective as of June 1st, 2021, and will be applicable to all taxable years beginning after June 30th, 2021. When applying for the homeowner's tax credit, that applicant needs to submit a copy of the will, trust, or non-probate instrument for the deceased homeowner, a copy of the death certificate for the deceased homeowner, and a copy of the documentation that shows that that surviving family member is related to the deceased homeowner by either blood, adoption, or marriage. This bill will essentially allow our surviving heirs to keep the homeowner's property tax credit while still going through the costly and time-intensive probate process. All right, thank you. Can we go to the next slide, please? All right, thank you. And so the last bill I'm going to be talking about today is House Bill 39. So while there were no significant family law changes this year, House Bill 39 requires a court to waive a certain publication requirement in an action for a change of name under the Maryland rules on motion by the individual who was filed for the action. So for many of our clients, this publication requirement can be an insurmountable cost barrier. And additionally, for clients who are coming out of abusive relationships or are transgender, this requirement can be unsafe. And I think at this point, I'm gonna hand it back over to Asia.
I can take it from here. Thanks, Tim. I'm Chris Sweeney. I am a staff attorney for our Workforce Development Project, and I'm going to be talking about 4 pieces of legislation that have a substantial impact on the way that criminal record expungement is going to operate. So there are some new convictions added to the list of potentially eligible convictions. There's some changes to the penalties for driving on a suspended license. There are some significant changes to Maryland judiciary case search in the criminal context. And there is the passage of automatic expungement. So we'll get into those 4. So new convictions that were added to the list of eligible convictions, which is found in Criminal Procedure 10-110. For a long time, there was listed 1st, 2nd, and 3rd degree burglary convictions among that list of eligible convictions. For some reason, 4th degree burglary was absent from the list until this year. So 4th degree burglary being, of course, the lowest level offense of the 4, so more common for our clients as well, has now been added. So that is no longer going to be counting as a subsequent conviction that would permanently block other expungements or count against the unit rule. It's subject to all of the same requirements for expungement as anything else. And that is actually going to be a 10-year wait to expunge that conviction. And then driving on a canceled, suspended, or revoked license, which is probably an even bigger and significant change to the way expungement is going to work. This is a very common conviction to have for our clients. We have seen it prevent the expungement of many other, even more serious offenses that would otherwise be eligible. So any violation of the Transportation Article 16-303 is going to be eligible for expungement on a 10-year waiting period and subject to all of the other rules, such as no subsequent convictions. It is important to note that this does not include the offense of driving without a license. So if someone were to have never obtained a license to drive in the first place and then was arrested, that is a different offense than driving on canceled, suspended, or revoked. Next slide, please. More on driving with a suspended license. This is not an expungement law on its face. However, this change to the penalty for driving on a suspended license does affect expungement in a significant way. So the penalty for driving on a suspended license in specific contexts, which are listed in the bullet points here, has been reduced from possible incarceration to simply a fine-only offense. The way that this affects expungement law is that it is not a conviction for this type of driving on a suspended license does not count toward the unit rule, so it would not block an expungement from happening if it were to be part of the same set of charges. There is a good faith argument to be made for expungement that a conviction for this type of charge should not count as a subsequent conviction as well. It's also important to note that non-incarcerable traffic offenses actually do not follow the same rules for criminal expungement. So this would no longer even be part of the expungement process. In a way, it would go through the MVA if someone were to want to expunge a non-incarcerable offense from their record. It's also important to note that this offense has not actually been decriminalized. It is still considered a criminal offense. It's just that the fine is the only possible penalty. And you can move on to the next slide. Okay, so some pretty significant changes to Maryland judiciary case search. This actually went into effect over the summer. And essentially what happens is any criminal charge that resulted in either a null pros, acquittal, or dismissal is not allowed to be shown on the Maryland case search. The charges for the case overall are not expunged. They are not automatically legally shielded. They are simply hidden from that website. They would still appear on a fingerprint check. They would still appear in public court records or really any other publicly accessible avenue of finding court records. They are still appearing on the MDEC e-filing system and its case search that is attached to the MDEC system. It's also important to note that this is applying to individual charges. So if someone were to receive, say, 4 charges in a criminal case, they were convicted of 1 of the 4 and received a null pros on 3 of the 4, the 3 null process would disappear from case search. Again, they are not actually being expunged. There isn't really a legal consequence to their removal as far as who is allowed to look at them. They just don't appear on that website. So they still need to be expunged if you have a client who wants their eligible cases expunged. They'll just have to be found through other means, such as a fingerprint report or that smart search. We have materials and presentations on our attorney resources page on our website for a lot more detail about how to complete an expungement in light of many eligible cases not being found on case search anymore. Next slide. Finally, automatic expungement was actually passed this year. It's something that many advocates have been working for a number of years. What's going to happen is that cases where every charge in the case resulted in either a nol pros, acquittal, or dismissal must be automatically expunged after 3 years from the date of disposition. This is not retroactive, which means that it only applies to criminal cases that occurred on or after the effective date of October 1st, 2021. What that means is, in a practical sense, we really won't see anything happen from this legislation until October 2024, when eligible cases will start actually having to be automatically expunged. In the meantime, anyone who has an eligible case is still free to file an expungement before this happens. So any case that this applies to is eligible for expungement immediately, subject to the other prerequisites, such as the defendant not being a defendant in another pending proceeding. So if you had a client who wanted to expunge a case early or before it's going to be automatically expunged, that's still perfectly okay to do. There were really no procedural changes to the ordinary expungement process. And finally, it's important to note that expungement remains a very necessary practice area. There are thousands of cases eligible for expungement that occurred before this law went into effect that are completely unaffected by automatic expungement. And in the meantime, during that 3-year waiting period, many people may seek to have their case expunged before it comes off automatically. Again, just as one final comment, the last 2 slides, automatic expungement and case search changes, there is a lot of detail to these processes that we do have presentations dedicated entirely to those topics that can be found on our website. And that's it for me. I think I'll turn it over to Amy.
Thanks, Chris. So the first topic I'm going to dig into a little bit is the landlord tenant law changes. And there were some really big ones this year. The 2 that are on the screen have a variety of components, and the sort of thread between them is the notice requirements. The first one, House Bill 18, which just went into effect. So I think the first most important thing is that it creates a potential right to counsel that's now going to be administered by the Maryland Legal Services Corporation. I think one of the more important things about this is that there wasn't actually a funding bill. There wasn't actually funding for this that was actually put into the bill as well. There are some efforts right now to get some funds from the American Rescue and Recovery Act that passed in March of the federal act that passed in March of this year to direct some of those funds to the access to counsel. There appear to be some funds kind of left over that will not be spent by the state that could be directed towards this. But with the notice requirement, the interesting thing that certainly is going to be necessary for advocates to be aware of is that there's now a 10-day notice if a landlord is going to attempt to get repossession of the property for non-payment. And the tenant has a right to cure within those 10 days. That notice can be given one of essentially 3 ways. The first is affixing it to the door. The second is first class with a certificate of mailing. And the third is a potential electronic option. If the tenant has elected that would be something that might occur in, say, new leases where the tenant elects to receive such notices in either email or an electronic portal that many of the kind of large landlords operate. With Senate Bill 401, for non-renewal of leases. The significant impact here actually breaks down depending on how long the lease term is that it is going to be ended. If we're talking about a year-to-year lease, then or where the year lease is coming to a close and the landlord wants to not elect to continue on, then we're talking about a 90-day notice period, and this is statewide. If it's a month-to-month lease, it is a 60-day notice period, and previously there had been a 60-day notice period only in Baltimore City and a 30-day notice period in other counties, and now it is a 60-day notice period for statewide. And then if it is if it is a week-to-week lease, there is at least a 7-day notice that has to be given, and if there's no lease agreement, there's no term of tenancy, at least 21 days have to be given. So all of these really impact how the lease process is going to come to an end. We've seen a lot of landlords in the moment that we're in right now elect to use the non-renewal of leases in order to evict even potentially tenants that are that have potentially not paid just because of the backlog in those non-payment cases in jurisdictions across the state. And so this is actually going to provide greater notice to tenants in order for them to know that their lease is coming to an end and give them an opportunity to find alternative housing. Next slide, please. So the Medical Debt Protection Act of 2021 was a really, really big deal. The slide says that it prevents hospitals from collecting debts when they have evaluated that person for financial assistance and prohibits wage garnishment and home loans and home liens. That is probably the biggest part of the bill, but in addition, it establishes there are guidelines established that absolutely no one has to make payments that are more than 5% of their income, which is a really big deal. So that you're entitled to be able to get a payment plan on your medical debt, and your hospital debt, and that it has to be a small enough portion of your income. The other thing is that it actually prohibits any debt collection whatsoever from hospitals until these guidelines are established. There has been no establishment of guidelines, and so there should be no hospital lawsuits. If you were seeing any, maybe reach out to me and let me know. These are really important changes for people that should have received access, should have received discounted medical bills or free. The bill should have been free based on their income, and they were never given that financial assessment. Never heard that financial assistance was possible. This is sort of sometimes called charity care, but the sort of term that all hospitals would be using is financial assistance. And the one other thing that I will mention about that is that there was a study done last year, I believe, that indicated that something on the order of $60 million was collected from folks that should have received free or reduced cost care. And so this isn't necessarily going to get money back into those folks' hands, but it will prevent that from happening this year or next year. So it's a big deal. The one other thing that was initially included with this legislation that was not included in the final legislation was a ban on lawsuits under a certain amount. But we'll see if that changes in the coming years. The one other bill, House Bill 842 on here. This is just a kind of good to know bill that passed that folks can go to the electric company and request usage for the last 12 months. This is actually really useful if you're going to be moving into a new apartment or a new house and you want to get a sense of what the electric bills are going to be like. And so this also just went into effect. Next slide, please. All right, the tax credit and the earned income tax credit. There were two big changes this year with the tax credits. One was the expansion of the earned income tax credit for the next 3 years for low-income folks, but in particular low-income folks with children. It creates an additional credit for those folks on their Maryland state taxes to just give folks living out of below the poverty line is effectively a bit of a boost. The one other major change was that it allowed for the possibility of some immigrants who are I-10 holders to receive a small credit, not as large of a credit as other folks receiving the earned income tax credit, but a little bit for those folks in a very narrow set of circumstances. But it is about 40,000 Marylanders, which is a big deal, and especially useful when folks are struggling. And so I think with that, that concludes the crux of the presentation on some major changes that will be helpful for you and your clients as you're moving in the new world with all of these changes that between the items that we talked about here, there's some pretty significant stuff. Asia, I'll turn it back over to you.
All right. Thank you, Amy, Chris, and Tim for your presentations. If you all have any questions, you can put the questions in the chat. Meanwhile, while I'm waiting for your questions to come into the chat, you can definitely follow MVLS on our social media accounts. We have Facebook, LinkedIn, Twitter, and YouTube. YouTube, you can find all of our additional training videos, as well as if you're looking for other resources to help as an MVLS volunteer or pro bono cases, you can always go to our pro bono portal, or you can always go to our website to find other resources to help with your cases, or to just find more information about the laws and the legislative changes that were discussed during this training today. Of course, this is what our MVLS pro bono portal looks like. And we have free upcoming training and other volunteer opportunities that you can find here and also on our website as well. Again, we also have more recorded trainings on our website. And if you are not an MVLS volunteer, this is a perfect opportunity for you to sign up today. Seeing no questions in the chat, I want to thank our presenters today for their time and for explaining some of the new changes that went in effect this year in Maryland. Thank you for joining our training today, and I hope you all have a good rest of the afternoon.
Thanks, everyone.